say the restrictions that you impose on the freedom of speech, first of all, you have to define them through a law.
No, but Article 14 gives privacy of home.
Bilkul, sir.
So
the question over here would be, is this offense relatable only to privacy of home? Because what it is applied to is that this is our private, if a journalist is reporting on some public official's conduct, he says, this is my private affair, you have breached my privacy, and therefore the FIA should pick you up. That is the problem, sir.
You can't just throw out privacy. You can qualify it.
Yes, sir. Bilkul.
How would you qualify it?
What happens is, sir.
No, what happens, Shone? Again, that's
case law.
You the best law you can misuse.
Ji.
So that's we're going to. How would you like to qualify privacy?
My lord, the same way that if there is some particular kind of thing that they are looking to stop, that is,
can someone photograph you in your sitting room, washroom, or wherever? I would imagine you will say no.
Yes, sir.
So how would you attend to something like that then?
My lord, that is the function of the legislature. The reason is
that's not defamation; it's privacy.
Ji, sir. Ji,
sir. Someone is taking pictures of you.
Yes, sir.
So there is no defamation here. Yes. It may be defamatory as well, but that's another aspect. But generally, it's not. It's just a privacy issue.
It may be a breach of privacy issue. Now,
if you take out privacy completely, then people will be leaning over the wall and taking pictures of you, and they find that they can't do anything.
Yes, I appreciate your lordship's point. That has to be protected, and it is a permissible object under the exceptions to Article 19. What I'm saying is that if the law is vague, it can cover everything and nothing.
That's why I'm saying, can you suggest some qualifying words that we can then interpret Section 20 in that manner and restrict its scope? That's what we are asking you.
My lord, it would be, I mean, I could come up with some formulations right now, but there may be things I miss, and it may be too broad or too narrow.
By all means, you can supplement them later. I'm not saying give an answer now and then, because when I put it to you that or harms the reputation, you're saying this is domain of defamation. If there's a thief, I call him a thief, I'm not defaming him. But of course, I'm harming his reputation. So, but then the burden will shift on you, and I can sue you for defamation or whoever the concerned person is. Point taken. Because the judgment of Justice Athar Manila does not talk about privacy.
No, it doesn't.
He left it out. You want to introduce something new now.
Yes.
So we are going to do that under 184(3).
Yes.
Zara sa soch le, kyunki like you said, it could have. Someone is taking pictures of your child. Would you want that?
That is,
even if the child is not in your home, would you, in a park, would you like someone taking pictures of your child?
No, sir.
So don't do it.
Bilkul.
You can complain and it may come to haunt you.
Sir, agar aap Section 24D dekh lein, when they want, they specifically define it.
No, you do it. You define it.
Zara agar dekh lein, sir, Section 24D.
24?
D.
B or D? B. It's a B, D to hai.
D. 24C and 24D.
No, that's an extreme case. Let's not go there. I'm talking about normal. Your child is playing football in a field or cricket or whatever. Would you want your child pictures taken?
D covers that also, sir. Agar aap 24D cyber stalking wala jo hai, take a photograph or make a video of any person and distributes it or displays or distributes it without his consent.
What is the email right?
24D, sir.
Small d, sir.
24 A, B, D का okay, small B.
प्रेस लेटर को आवाम के सामने लाके कल से
कल से सुप्रीम कोर्ट का लार्जर बेंच इसकी हेयरिंग शुरू करे।
Okay.
Take a photograph or make a video of any person and displays or distributes it without his consent in a manner that harms a person. ऊपर फिर है watch or spy upon a person, C में watch or spy upon a person in a manner that results in fear of violence or serious alarm or distress in the mind of such person. Now, if
So you are saying that 24 attends to
ये स्टोरी है क्या? जजेस तो तोहफा नहीं देते ना भाई, थोड़ा सा तो उसे रियलिस्टिक करना पड़ेगा।
legitimate privacy interests, but in order to protect them, they have to actually formulate a specific law protecting a specific thing. If you just say that anything that breaches privacy is illegal and punishable with imprisonment, that is an overbroad, overgeneral curb on the freedom of speech. That falls afoul of Article 19 as per the case law developed on this subject.
Can you articulate something precisely on this? You don't have to do it now. You can file something on this privacy, keeping in mind what 24 hasn't already covered. So those kind of things, or so we can come back to it. So can we move ahead?
Sir, bilkul. Sir, as far as Article 19 is concerned, as I was saying before your lordship, sir, that
in your petition you don't challenge this, or do you do challenge?
My lord, I have pointed out that this the privacy aspect of it has not specifically been dealt.
अस्सलाम वालेकुम सर, ये लाइव का थंबनेल मैंने बनाया था थोड़ा क्लिक बेट खेलने के लिए। तो वीर गौहर खान की प्रेस कॉन्फ्रेंस थी उमर अयूब के साथ।
To strike down something.
Yes.
The other is to read down something. The third is to interpret something. Our interpretation also in a way becomes a law. So keep all these three aspects in mind, because I don't think we should do striking out, but maybe we can do the next two. Unless you can persuade us otherwise.
My lord, let me begin with Article 19, sir. Sir, उसमें तीन चीजें important है. One is that the exceptions to freedom of speech is
Reasonable.
one, that it has to be reasonable.
And
Number
imposed
two,
by law.
it has to be imposed by law.
Take.
Number three, it has to meet one of the 7 objects mentioned in it.
I find 8, you find 7.
My lord,
Let's start counting them. Glory
of Islam, integrity, security, or defense, I treat them as one, sir.
2.
Two, friendly relations with foreign states.
3,
public order.
4,
decency or morality. 5.
No. Decency is different from morality.
Then it will be 8. So
Okay.
I treated decency and morality as part of the same, but then it will be.
I know there's common ground, but I think they're two different.
ठीक है, sir.
And if the Constitution has used 2 different phrases,
Fair enough,
who are we to
Fair
dilute there?
Fair enough, sir. Then in relation to contempt of court, and then this is important, sir, commission of or incitement to an offense.
I think this is the most important one.
Yes, sir. Because your lordship will appreciate that before the 4th constitutional amendment, this specifically included defamation. Defamation was omitted. Defamation was, instead of commission of, it used to be defamation or incitement to.
Defamation was there in the original Constitution
Ji, sir.
and was removed by the 4th Amendment.
Ji, sir.
When was the 4th Amendment?
So that was 1975.
21st November 1975.
And removed
देखें आप लोगों ने सत्यानाश कर दिया इसका
4th Amendment.
मतलब पूरी की पूरी स्टोरी का। स्टोरी ये थी कि इस्लामाबाद हाई कोर्ट के जजेस की एजेंसियों पे इल्ज़ामात के बाद तहरीक इंसाफ के लीडरों ने भी बड़ा मुतालबा कर दिया। ये थी स्टोरी। अब ये जजेस का तोहफा, इमरान खान कामयाब, I mean that's not the story. The whole world is talking about that context. इस्लामाबाद जजेस के एजेंसियों पर संगीन इल्ज़ामात, तहरीक इंसाफ ने भी बहुत बड़ा ऐलान कर दिया और बड़ी डिमांड कर दी। ये थी स्टोरी यार। देखें आप लोगों की कैप्शंस वगैरह कैन मेक और ब्रेक। प्लीज चेंज द थंबनेल एंड बी स्पेसिफिक।
it was there in all, defamation was there in all the previous constitutions. It was there in the original 73 constitution, but it was removed in this, in the 4th Amendment. Now, my submission is, sir, that the purpose of that removal is to decriminalize defamation, and that is the international trend, that defamation is in many countries, they have, where they had criminal liability.
Mr. Sirajuddin Ahmed, there's another case pending before this court, case of two very famous Pakistani singers, where one alleged sexual harassment against the other, and the other resorted to criminal defamation. And one of the questions posed in that is exactly what you're saying. ये है आपका reported
Nisha Shafi's and
नहीं वो
Ali
reported
Zafar's,
है या उसका प्रिंट आउट दे दें नहीं उसमें मेरे ख्याल में एग्जैक्ट एक क्वेश्चन आया so we can leave it for that because it because ये है हमारे पास अच्छा चल I'll continue.
My lord, this is important actually, that case also, and I had advised at least one person who received an FIA notice in that case as well, for expressing support for what Nisha Shafi had said on Twitter or Facebook.
Let's not
And they
argue that case.
I'm not arguing it. I'm not arguing
let's
it.
not
What
take
I'm
names,
saying
huh?
is that Section 20 was applied in that case as well. Notices were sent by FIA on that ground as well. So what I'm saying
जो
is
स्टोरी की लाइफ के अंदर
that
आपकी
the
मैं टैग्स भी देख रहा हूँ ना
criminalization of
हैशटैग्स नीचे
defamatory
डिस्क्रिप्शन
speech,
में भी
whether it be
वो
done
भी
through Section
रेलेवेंट
20
नहीं है
of
अडियाला
PICA
जेल का
or
इस प्रेस
otherwise,
कॉन्फ्रेंस से हार्डली
that
कोई
would
ताल्लुक है
itself fall afoul
अलकादिर
of
ट्रस्ट केस का भी इससे कोई ताल्लुक ही नहीं है व्हाट इज अलकादिर ट्रस्ट का गॉट टू डू विद इस्लामाबाद हाई कोर्ट की प्रेस कॉन्फ्रेंस के वक्त इसका ताल्लुक इस्लामाबाद हाई कोर्ट की प्रेस कॉन्फ्रेंस से है ISI से है जजेस अंडर प्रेशर से है जजेस एलिगेशन से है कैमरास इनसाइड द जजेस होम से है इन चीज़ों से इनका कहीं पे आपने जिक्र ही नहीं किया हाँ ठीक है देखें जिसका शाम पर ने कहा सोर्स ना होना अलग बात है थंबनेल और कैप्शन गलत होना अलग बात है देखिए आपका दुनिया की बेहतरीन से बेहतरीन स्टोरी होगी अगर आपका उसका थंबनेल और उसका कैप्शन सही नहीं होगा तो वो नहीं चलेगी इसका एग्जांपल मैं आप लोगों को पहले भी दे चुका हूँ एक दफ़ा आप लोगों ने एक स्टोरी दी थी जिसका कोई ताल्लुक ही नहीं था थंबनेल आपने बिल्कुल डाला था उल्टा अफगानिस्तान पे जो हमला हुआ था तो आपने कहा था कि जी दहशतगर्दों के ऊपर हमला पाकिस्तान की आर्मी ने कर दिया और द मोमेंट वी चेंज इट टू कि पाक फौज का अफगानिस्तान के अंदर हमला जो कि जेन्युइन स्टोरी थी उसके बाद उसकी व्यूअरशिप एकदम स्काई रॉकेट कर गई थी इसी तरीके से मैं ये देख रहा हूँ कि आप लोगों की स्टोरीज अच्छी होती हैं लेकिन आप लोगों के थंबनेल भी नहीं रेलेवेंट
You can skip the factual aspects and you can turn to paragraph 4. Leave is granted to consider the following.
Whether Section 20 of PICA and any other provision thereof violate Article 19 of the Constitution, whether the defense of truth is undermined by Section 20 of PICA by criminalizing defamation, whether the criminalization of defamation negates, dilutes and or suppresses the fundamental right of freedom of speech and expression, whether, my lord, this would cover exactly
इसीलिए
some of the grounds.
read on.
Whether an anomalous situation is created if both a civil case claiming damages on account of defamation and a criminal prosecution for defamation proceed and or to do so simultaneously, and whether this would undermine the fundamental right of a fair trial and due process enshrined in Article 10A of the Constitution, whether by invoking PICA against victims of sexual harassment and victims of other crimes amounts to silencing them and perpetuates injustice, whether Section 20 of PICA deters the wrong from accusing the wrongdoer and infringes the permission specifically granted to the wrong, that Allah does not like that evil should be uttered in public except by one who is wrong, Al-Quran, Surah Nisa 4 verse 148, whether the petitioners could have recourse to this court without having filed ICA, and then, my lord.
No, वो the other one, two technical ones. Does this, I think this is much more than what you're saying.
Yes, my lord.
Have you left out something?
No,
here?
this covers most of what I intended to argue before your lordship, which I made my submissions on.
So had you not read this order?
My lord, I had not seen this. I had
अगर
not,
आप पहले कहते तो हम इसको भी लगा देते साथ में केस को.
sir.
So I think इसको पर I don't want to, because it's a matter pending. Either we fix it with this one, but this is specifically to journalists, and that is not really specifically to journalists, but it's the. I'll tell you what the difference is. In a way, it will be on their rights. Here you are asserting journalistic rights. This case, on the contrary, is pushing journalism back. And these are my private rights, don't interfere. So, do you see what I'm... because, you know, privacy, वो होता है ना वो क्या paparazzi, and they chase people or take pictures from drones and stuff like that. So that may be contrary to what you are saying, because journalists will say, why can't I do so? And this is a pushback.
My lord.
So,
My lord, perhaps this aspect then, Article 19.
maybe we agree with the वो जो जैसे Athara Miller's judgment, that words, but privacy, since he did not touch upon, and since the matter is already before this court in this other case, maybe we can just leave it aside, or alternatively, if you feel strongly, become a party in that petition and come there.
May I make a suggestion, sir?
Ji.
As far as my Article 19 challenge and Section 20 PICA challenge is concerned, that obviously covers common ground with that case, with Misha Shafi's case. That aspect can be heard when that file is called, or when that appeal is heard. The other aspect of this case regarding the abuse by FIA, which I was earlier talking about, were cognizable, non-cognizable. There are 3 or 4 other issues. Perhaps then I can go to those right now and reserve the part.
ठीक है. So I think we leave this one aside.
ठीक.
ठीक. But you are welcome to, if you now you know it, if you want to become a party.
My lord, I would obviously like this petition then to be heard. So
No. This
on
petition pertains to journalists' rights. Like I said, this is an exception to journalistic rights. Because surely it's not the privacy of journalists you're talking about. It's invasion of privacy by journalists. It will be placed the other way around.
I see, in particular, the question number 3, whether criminalization of defamation negates the fundamental right of freedom of speech. That is what I'm arguing before your lordship. That is precisely the
नहीं,
question.
मतलब उसमें हमने काफी वाइड रखा है चीजें को.
जी, और भी aspects हैं, but at least if your lordship is deciding that issue, then I would like to be heard.
ये हमें जरा सोचना होगा, उसको क्लब करें, क्या करें. Can you cover other ground?
जी, मैं other ground. Sir, on the last date, I pointed out that Section 43 of PICA only recognized cyber terrorism, electronic propagation of sexually explicit material, and child pornography and related offense, child exploitation and related offenses to be cognizable. All the other offenses in the PICA law are non-cog. Now, the difference, there are three crucial differences, sir. As your lordship knows, one, that an FIR can't be registered in non-cog, that investigation can only be done if...
So the law is all right.
Yes.
It's misuse. It's been
Right.
misused or misapplied or
Yes.
intentionally, you're
Yes.
saying.
And it has been done since 2016 when this law came. It was done in the Nawaz Sharif government, in the Imran Khan government, and now I'm here before your lordships again. Consistently, FIA has been using Section 20 as if it is, allows it to carry out arrests.
One thing could be that you can educate FIA.
I don't think I'm capable, sir.
No, we can maybe appoint you, explain the English language, what is the intent of the law. I think it could be lack of education. Or
I don't think the problem is English, sir.
Hey, but at least you should not condemn somebody just like that. It could be.
Perhaps the learned Attorney General will explain when his turn comes. But sir, what I was pointing out is that three crucial differences which they ignore is one, they can't register an FIR, two, they can't start investigation on their own. They have to wait for a magistrate to order. And number three, they can't make arrests without permission. So far as journalists are concerned, if this free hand to FIA is checked, then many of our grievances will be redressed. Fine, we'll still have to go to the magistrate, etc. when a criminal
Can
complaint
you
is
show us
filed.
the notice which was actually sent?
जी बिल्कुल सर ये है सर पेज
इसी में
मेरी पिटिशन में CP 4 में if your lordship sees page 18 there are many notices sent to many different journalists. I'll just point out one notice.
Page?
And sir, page 18 is a notice.
Can you read it?
Ji.
Forget the names, just read the
Ji, sir.
content.
So the only important thing over here is the gist of allegations. The complainant is their own officer, so there's no private complainant.
Read the gist of allegations.
Explicit and malicious campaign against honorable judges of Supreme Court of Pakistan.
No, continue reading.
Ji. Therefore, you are directed to appear before the undersigned to record your version at FIA's Cybercrime Reporting Center on such and such date at so and such building, positively in interest of justice for fair trial process. In case of non-appearance, it will be assumed you have nothing to present or state in your defense.
This is a notice under 160 CRPC.
Ji, sir.
Let's read 160.
Any police officer making an investigation under this chapter may, by order in writing, require the attendance before himself of any person being within limits of his own or any adjoining station, who, from the information given or otherwise, appears to be acquainted with the circumstances of the case, and such person shall attend as so required.
Has the law been violated?
Yes, sir.
How?
They had no power to investigate. There was no magistrate's order.
No, at the moment, no FIR has been registered.
Yes.
This is pre.
Sir,
Yeah, I'm just trying to understand.
Ji.
It doesn't say after registration of an FIR.
sir,
I mean, you may be called upon as a witness even. Yes.
sir, investigation.
Again, let's go logically. Tomorrow I can receive a notice. Someone may mention me as a witness. It's not the case is against me. So I just want to, you can say it, this is a intent, they want to harass me, वो तो एक अलग बात है, but are they proceeding legally or not? ये हमें देखना है ना.
जी सर.
ठीक है, वो मिसयूज वाली बात अलग होती है. वो आप किसी को भी, अब हो सकता है कोई कल कोई पता नहीं कोई केस हो, मुझे क्या पता, कोई बैग में डाका हुआ था और वो खड़े थे सामने, मेरा नाम लिख दिया, तो पुलिस मुझे नोटिस दे देगी. ठीक है, तो ये उन्होंने उस किस्म की नोटिस दी. अभी आपका केस तो कोई रजिस्टर्ड नहीं है, मुझे पता नहीं कि किस लिए है.
Not someone
When
is
I
accused.
go there, I'll find out.
Someone is accused.
अभी उन्होंने आपको accused तो नहीं nominate किया ना. It's not you are FIR has been registered. Why are you assuming it? They may want to exonerate you, or they may want to harass you.
My lord.
Yes, sir. Attend to this.
Ji. Sir, the way I understand it is that FIA has no power of investigation unless it relates to a cognizable offense. If an offense
राहुल
is
साहब,
जी
ये आपका कहीं नुकसान ना कर दे ये चीज. मैं आपको बताऊं,
जी सर.
कभी कभी ऊपर से बहुत प्रेशर आता है, ठीक है, तो वो कुछ करने के लिए, दिखाने के लिए कार्रवाई, शायद वो भी अफसर समझता हो कि जी ये काम सही नहीं है, सर हमने नोटिस दिया, तो जरा सा प्रेशर भी उन्हें डिफ्लेक्ट कर दिया, आपको भी उन्हें अरेस्ट नहीं किया और FIR भी नहीं काटी. They kind of, I mean, let's live in the real world. Maybe this could be that, maybe it's not that. Otherwise, they can just simply go and register an FIR, pick you up, arrest you.
My lord, they have not, except for one person, they didn't arrest anyone actually. But this is exactly what the design was. You make an open-ended inquiry.
देखिए,
जी, मैं जरा आगे
नहीं, जरा देखिए ना, we can't strike down a legal action. If you can say it's an illegal action, we can strike it down. We cannot read what is in the mind of a person issuing the notice unless it is obvious. ठीक है? So if we make those precedents, then तो कभी genuine inquiries में वो कहेंगे जी ये सुप्रीम कोर्ट का जजमेंट है, आप हमें नोटिस ही नहीं दे सकते.
जी सर.
They may just want you as a witness. They may want you in other capacity as well. They may, I don't know, whatever capacities there are.
Sir, let me try and explain myself, sir. The law is that if it is a cognizable offense, FIA or the police can investigate of its own accord. If it is not a cognizable offense, FIA cannot investigate, it cannot inquire, it cannot do anything.
You're missing the whole point. Read again section 160.
Ji, sir.
Read the title of section 160.
Power, police officers' power to require attendance of witnesses.
Witnesses.
Yes, sir.
It doesn't say accused,
Sir,
or potential accused.
My lord, if we are dealing with practicalities, your lordship knows the section 160 notice goes, you appear before the office, then it is at the discretion of the FIA to keep you there or not.
I gave you an example
Ji, sir.
where a officer who's under pressure is finding a solution to keep you also, to keep his, whoever is pushing him pacified, and at the same time not to harm you. We have to see all the scenarios. So they talk a middle way. अगर हम कहते हैं कि ये notice दे ही नहीं सकते हैं FIA, तो we are striking down section 160.
No, not at all.
Then
section 160 says any police officer making an investigation. How are you making an investigation when there is no FIR?
It says require attendance of witness.
जी sir, आगे sir. Any
लेकिन that is also there. Naturally there will be some investigation.
Sir, वो तो title है ना, attendance of witness. उसके नीचे जो actual section है that says any police officer making an investigation under this chapter may require the attendance. How can you make an investigation when there is no FIR? Without an FIR, how? And you can. Offense. What happens is that on a non-cog offense,
how do you know there's no FIR?
That has to be protected. Sir, then they have to disclose it. That is the object.
Yes. Witness को disclose करने की
बिल्कुल है sir. Sir, 2012
SCMR से पहले कानून खत्म कर लेना.
जी sir.
We always run to SCMR. We just finish the law.
Sir, if your lordship will look at 154 and 155 also. In 154, that relates to cognizable offenses. Then 155 relates to non-cognizable offenses, and 155(2) may be seen, sir. No police officer shall investigate a non-cognizable case without the order of a magistrate. Now, that is the crucial difference.
No, 1 second. When you issue a notice under section 160, do you have to say FI number so-and-so has been registered against so-and-so after obtaining permission of a magistrate, make all this disclosure, or can they just say, can you please come?
No, they can't say that, sir. The FIR is a predicate, and then when
I'm just saying the notice doesn't need to mention that.
so the notice does, has been defined by this court, that you cannot give vague information to citizens and require them to appear at police stations. You have to tell them the offense. You have to tell them the details of the allegations.
Wait, does it,
you have
160 doesn't say that.
My lord, that is the interpretation that has been taken by this court.
Now let's go to interpretation.
Ji, sir. Because
No, show us the interpretation.
sir,
Which citation?
sir, ये PLD 2012 है, I'll just PLD 2012, Supreme Court 903.
PLD 2012 90
903, sir.
ये section 160 पे
जी sir. जो NAB, in the context of NAB.
we are going to do that under one. Tell us 160.
Sir, NAB भी 160 का ही notice वो
So where is that portion? Let's read that portion.
sorry sir.
Let's read that portion pertaining to section 160 notice. Because we are dealing with a notice that was issued to you under section 160.
If your lordship sees para 13. May I read, sir?
Error?
13 at page 914.
Ji.
The clear and unambiguous pronouncements given in the case titled Ghulam Hussain Baloch and others, PLD so-and-so, were violated by NAB in its two letters. In the cited precedent,
ये तो हमें नहीं पता ना, section 160 का जिक्र कहाँ कर रहे हैं, ये बताएं.
sir, the provision of the NAB law and the provision of section 160 are pari materia. This is the same.
तो हमें कोई नैब लॉ का कोई प्रोविजन तो पढ़ देना
जी
पहले.
सर.
तो लेटर्स की दो बातें हो रही हैं, मम्मी पता नहीं क्या था उस लेटर में.
Sir, अगर मजीद पढ़ लें, it's the same thing. It's requiring attendance of witnesses. In the cited precedent, NAB has been given express guidelines as to its responsibilities while summoning or requiring attendance of persons, witnesses in an inquiry. As per ratio of the case, before summoning a person to attend, NAB was bound to identify and particularize the information sought from any witness, to state the nexus between such information and the subject of the inquiry being conducted by NAB. It was observed by the court that while calling for the information from any person, the person must be informed of the fact, point, allegation, offense, name of accused, specified matter, if any, concerning the matter in the notice, so that the person can furnish such information. None of this was done by NAB.
Show us the NAB ordinance.
Ji, sir.
Refer to the provisions in the NAB ordinance.
The chairman NAB, subsection 19.
मैंने पहले निकाल लिया था.
ये देखिए, ये बहुत स्पेशल लॉ है. ये तो चीजें दे रहा है, स्पेसिफाई कर रहा है, ये दो, वो दो, फलां दो. अब ये 160 CRPC वाला लॉ is not so detailed. Actually, you make sense. It has to be regarding something. Fine, that point taken. But NAB, I don't think can you give a non-NAB case on this?
My lord,
Because NAB case actually says that before you issuing a notice, because power to call for information, and it has a very detailed section which is completely different in its language from section 160.
my lord, the Islamabad High Court has
Can you
followed.
do a general law
Ji.
on criminal procedure,
sir,
not a NAB law?
Ji, Islamabad High Court has followed it specifically for FIA also. It has applied this principle to
वो
FIA
दिखाए ना
notices. ये page 5 है sir वो booklet की.
जी.
The petitioner is a journalist. One of the most important functions of his occupation is reporting and informing the public.
Where are you reading from?
Sir, first page, sir.
Then he shows this. Yes.
8 and 9. Para 3 से.
वो भी NAB ही को refer कर रही है.
FIA
Yeah, I'm sure 160 has been interpreted otherwise. So this
कल
really
अपने
doesn't
इस्लामाबाद में
help.
लेवल
It's a
प्लेइंग
circular
फील्ड ना
argument.
मिलने की पीटीआई की दरख्वास्त पर फैसला महफूज कर दिया।
Don't
खबर
you have
आपको
any
दे रहे हैं
standalone case of
इस्लामाबाद में
160?
लेवल
I
प्लेइंग
don't
फील्ड ना
presently have one. I'll dig it out. But this was specifically to FIA notices. Now,
So it may well be, but they have applied the NAB provisions which are tailor-made for NAB. And this is a general law.
my lord, the scheme is the
If we
scheme.
start doing that, you may be empowering FIA with more things than they have. FIA will function under a normal law, not under the NAB law.
The FIA functions will function under the PICA and then
Under its own
and PICA
FIA
makes
Act and
CRPC applicable.
CRPC, सारे वो वाले लगेंगे ना?
जी sir, बिल्कुल.
तो आप ये उनको ज्यादा इख्तियार मत दे दें फिर.
Sir, section 160 की, if your lordship sees the scheme,
One?
160 CRPC की. Now, if a police officer, he is also a statutory functionary. If he is requiring my presence and if he is asking me some questions, he has to show that he has applied his mind. His notice to me must show that he has applied to his mind. If he is curtailing my liberty,
Chale, now you make, I'll place you in a very uncomfortable position. Can you for a minute become an officer of FIA and issue a notice under 160? Draft it. या तो क्या मैं कभी इशू ही नहीं करूंगा
नहीं बिल्कुल हो सकता है सर.
तो वो आप ड्राफ्ट करना है भी हमारी
सर उसमें आपने ये
आप जस्ट लिखें यू जस्ट स्पेल इट आउट यू मिस्टर ए आप बताएं.
My lord, it would start out with FIR number so and so, name of accused number so and so, that the accused has been charged with offences under section 21.
No, you are saying that basically what you want is disclosure of an FIR. You want disclosure of an accused. That's the point.
Yes, and the information that I'm being sought with. Your lordship will appreciate that even asking me to go to a police station and record a statement, that is a curtailment of my liberty. Fine, the law allows for it. But if you are asking me to do it, then you give me the reasons why you are asking me to come to a police station. Otherwise, why should I go to any police station because some gentleman in FIA or some gentleman in
Can't you be called pre-FIR?
No, sir.
Suppose, there's a scenario. Someone goes and reports to the FIA. Say, जी ये सलाउद्दीन साहब के फोन में ये explicit pictures of children हैं, ठीक है? One thing is register an FIR against you. The one thing is FIA thing, पता नहीं ऐसी तो नहीं है, उसको कोई दुश्मनी तो नहीं है, चेक कर लेते हैं सलाउद्दीन साहब, इनको बुला लेते हैं. मतलब we should be very careful of your rights as well. They don't just think of journalists because then वो होगा कि नहीं पहले FIR करो. So you have to go through the rigor of getting a bail before or a bail after, etc., where you may have a very good explanation or it may be a total false, fictitious case and FIR may throw it out without doing anything with it. We don't want to register FIR. But if you're going to force FIRs to be registered, I don't know, would you say कि किसने कहा, चाहे उसने कहा, then you may have a, I don't know, very good explanation or no explanation. Then they may take the next step. ये power है उनके पास या नहीं है?
Difficulty.
Forget journalists for a minute. Just general law पे आ जाए ना.
Generally जो difficulty create है.
या वो अच्छा दूसरा एग्जांपल दे देते हैं. सलाउद्दीन अहमद ने मुझे कहा है कि तुम मुझे 1 करोड़ रुपए दो, नहीं तो मैं तुम्हारे बच्चे को अगवा कर लूंगा. And they think, nahi, you're not that kind of person, you won't do it. Let me check with you. So you say, no, first register an FIR against me. Let it be a false FIR. So what do they, I mean, like I'm saying, place yourself in an uncomfortable position of FIR for a minute.
The way it works, and there's a slight difference between FIA and the police over here, and I'll explain why. Of course, and the judgments of this court on it, that the police does not simply, because someone comes and relates some information, the police is not duty bound to immediately register an FIR.
But they want to ask you things, but they still want to ask you things.
It has to, it may want to check things, it may want to ask people things, etc.
How do they do it?
What I'm saying is...
No, I don't care what you're saying. How should they do it?
Not what the
Because
police,
you drafted a notice, you wanted first FIR. Maybe they don't want to register, they don't want to check it out कि ये बात सही है गलत है, हम भी जरा थोड़ी बहुत तस्दीक कर लें अपने तौर पे. अब आपके घर आके नॉक करेंगे, आपको नोटिस भेजें, क्या करें वो आपके साथ?
my lord, they might come to my house and ask to talk to me without any compulsion.
आपको आगे आपके वारंट है, मैं नहीं आता हूँ.
So then I would...
भाई आपको लीगली तरीके से डील कैसे करें वो?
होता यही है
यार होता हमें पता है होता कैसे.
कानून भी यही है कि पुलिस जब तक FIR ना काटे तब तक किसी को कंपेल नहीं कर सकती. वॉलंटरीली अगर पुलिस मेरे घर पे आके मुझसे पूछे कि आपके फोन पे आप मुझे दिखाना चाहते हैं.
One question.
जी सर.
Section 160 of CRPC has to be applied and followed when there is Section 154, 155 or 150 already applied.
Yes sir.
Because these sections are contained in Part 5.
Yes.
And Part 5 starts from Section 154.
बिल्कुल sir.
Registration of FIR.
Sir.
Then 155, 160 cognizable, non-cognizable offences. And after that comes into picture 160.
बिल्कुल sir.
Develop this argument.
मैं यही कहने की कोशिश कर रहा था सर कि अगर वो FIR
सलाउद्दीन साहब, थानों में तो 2 रजिस्टर होते हैं, एक FIR रजिस्टर कहलाता है और एक NC रजिस्टर भी कहलाता है.
And also remember section 157 sub 2,
yes
where before registration of any FIR, the police is doubting the genuineness of the complaint and they may have inquiry.
आप हमें
Make out this case.
आप मुझे 157 का नोटिस.
157 sub 2.
बिल्कुल.
आप 160 पे बैठे हुए हैं आप.
जी, sir.
We want to take you elsewhere.
If from information received or otherwise, an officer in charge of a police station has reason to suspect the commission of an offence which he is empowered under section 156 to investigate, he shall forthwith send a report of the same to a magistrate empowered to take cognizance of such offence upon a police report, and shall proceed in person or shall depute one of his subordinate officer not being below such rank as the provincial government may prescribe in this behalf, to proceed to the spot to investigate the facts and the circumstances of the case, and if necessary take measures for discovery and arrest of the offender.
ठीक है. अब ये आपको कहना चाहिए ना, ये वाली provision. Would you be okay if you received a notice under 157, or that also they shouldn't issue you?
If
Just asking.
yes, if an FIR is registered, they have every right.
FIR की बात नहीं हो
Sir, वो लिखा हुआ है ना sir. If your lordship sees, if the officer in charge of a police officer has reason to
ये आप
suspect.
पता नहीं कहाँ से पढ़ रहे, मेरा आप ये कुछ और पढ़ रहे, मेरे पास कुछ और है.
156 sir. 157.
157 पढ़िए.
कौन सा पढ़ रहे हैं आप?
If from information received or otherwise.
1% पढ़ रहे हैं ये if from.
एक से
An officer in charge of a police station has reason to suspect the commission of an offence which he is empowered under 156 to investigate. 156 is cognizable
नॉन
offences.
कॉग्निजेबल वाला बताए ना.
सर नॉन कॉग में तो वो ये काम कर ही नहीं सकता मैजिस्ट्रेट के
भाई,
ऑर्डर के
जरा
बगैर.
देख तो लेना.
वो जी सर नॉन कॉग
This is not your department, इसलिए हम
सर नॉन कॉग तो 155
Let's read it.
जी
ऐसे
सर
आप ना
157
हाँ.
जी if from information received or otherwise an officer in charge of a
Where
police
are you reading?
sir 157
No, 155 पढ़ रहे हैं ना. नहीं, नॉन कॉग्निजेबल पढ़ रहे हैं ना.
non cognizable 155 है सर.
when
जी.
information.
Where information is
When?
given when information is given to an officer in charge of a police station of the commission within the limits of such station of a non cognizable offence, he shall enter in a book to be kept as aforesaid the substance of such information and refer the informant to the magistrate. No police officer shall investigate a non-cognizable case without the order of a magistrate.
ये आपको आर्ग्यू करना चाहिए.
सर मैंने ये पढ़ा था सर पहले.
नहीं, आप वो
I did read it, sir.
नैप पे चले जा रहे
Well, I did read this earlier, sir.
I forget that.
I'm sorry
My
if I
age
did
is
not place
catching
enough
up.
emphasis
Okay.
on it, sir.
हाँ.
तो ये मेरा कहना है
आज
सर.
आप 3 भी पढ़ लें.
जी सर. Any police officer receiving such order may exercise the same powers in respect of the investigation, except the power to arrest without warrant, as an officer in charge of a police
So
station.
the protection is inbuilt in the law.
Yes, sir.
They
Yes.
should issue you a 155 notice.
Yes.
That they can do so, provided the magistrate has permitted it.
Yes.
And
They can arrest me if
no, they can't arrest you.
if the magistrate gives the warrant.
हाँ, वो वारंट ऑफ अरेस्ट देना होगा.
बिल्कुल.
So,
That-
अगर आपको ये कहना चाहिए जी, अगर मुझे 155 की नोटिस भेज दें, मुझे कोई इतराज नहीं है. 160 वाली नोटिस उस वक्त भेज सकते हैं जब FIR हो.
बिल्कुल.
और तो ये कहना कि पुलिस आप जा ही नहीं सकते हैं, बुला ही नहीं सकते हैं, वो गलत है. आपको कहना चाहिए 155 की मुझे नोटिस दें, जहां तक हमें समझ आ रही बात.
और 155 का भी तभी होगा ना सर.
हाँ, जब मैजिस्ट्रेट
जब
उसके तकाजे पूरे
And
कर.
the reason why I am protected by that is that if I have genuinely maligned or defamed somebody
तो देखिए आप-
and he goes to a
हम
magistrate,
ये भी तो नहीं चाहते कि धड़ाधड़ी FIR लॉन्च करते रहें जब भी
बिल्कुल.
जरूरत ना हो. तो ये ऐसा भी पावर ना दें उनको. तो कभी कभी उनके भी जरा मसले होते हैं ना, जैसा आपको बताया. तो ये 155 की आपको नोटिस दे सकते हैं. ये बात हमारी सही है, ये इनकी कहना सही है. Do you agree? You are also not a criminal lawyer.
क्या करें?
आप क्रिमिनल काम करते हैं, आप
मतलब ये 160 के तहत
आप सिविल करते हैं.
जी मतलब क्रिमिनल मैं करता हूँ. मतलब 160 जो है इंक्वायरी का है. क्रिमिनल प्रोसीडिंग इनिशिएट जब इन्वेस्टिगेशन में जाएगा फिर होंगी. अभी तो ये इंक्वायरी स्टेज पे है. इंक्वायरी में तो किसी को भी बुलाया जा
देखिए, इनका बुनियादी छोटा सा अब जो बात हमें समझ आ गई. इनका कहना है ये 2 किस्म के ऑफेंसेस हैं. एक है नॉन कॉग्निजेबल, एक है कॉग्निजेबल. ये जो अगर ऑफेंस बनता भी है तो ये बनेगा नॉन कॉग्निजेबल. नॉन कॉग्निजेबल से है कि आप मैजिस्ट्रेट और ये 155 का प्रोसीजर फॉलो करेंगे, रिपोर्ट लिखेंगे, मैजिस्ट्रेट से परमिशन लेंगे कि मैं इन साहब को बुलाना चाहता हूँ, फिर आप उसको नोटिस देंगे 155(2) का. उसमें उस नोटिस में भी आप उनको अरेस्ट नहीं कर सकते हैं अगर मैजिस्ट्रेट साहब ने वारंट ऑफ अरेस्ट ले लिया हो. 160 में खतरा इसलिए है क्योंकि अब आप जा रहे हैं कॉग्निजेबल ऑफेंसेस में, तो ये आप जैसे ही आप जाएंगे आपको अरेस्ट कर सकते हैं. ये फर्क आ गया है दोनों.
मतलब जो 155(2) है वो भी इन्वेस्टिगेशन से ट्रिगर होगा, इंक्वायरी पे नहीं होता. जरा ये रीड आउट कर लेते हैं.
नहीं, मगर वो परमिशन ले लिए ना मैजिस्ट्रेट से, तो थोड़ा सा उसमें कुछ नजरसानी हो गई. एक हद तक प्राइमा फेसा है, हल्की फुल्की नजरसानी मैजिस्ट्रेट ने कर ली. हाँ चलो कर लो जाके,
खत्म हो जाती है.
इंक्वायरी
और फिर दूसरी बात यह है कि उसमें उसको खतरा नहीं कि मुझे अरेस्ट नहीं करेंगे. फिर उसको जाना होगा मैजिस्ट्रेट के पास, जी मुझे वारंट ऑफ अरेस्ट भी दे दें, कहेगा हाँ जी आप जाके अरेस्ट कर लो. तो इसमें डबल प्रोटेक्शन है जो 160 में नहीं है.
मतलब 160 के तहत तो अरेस्ट नहीं कर सकते जब तक ये कन्वर्टेड इन्वेस्टिगेशन में ना हो. इंक्वायरी के दौरान
तो फिर
arrest
आपने
हो ही नहीं
160 की
सकता.
नोटिस क्यों दी? आप 155 की नोटिस क्यों नहीं देते?
पायलट चौक
मैं आपसे सवाल पूछ
जी
रहा हूं।
पायलट इनका प्रोसीजर यही है
हाँ,
क्योंकि हो
procedure
सकता
कैसे
है ये
यार?
आके कहें कि मैं वो पर्सन ही नहीं
ये देखें, ये सीआरपीसी में प्रोसीजर ही लिखा हुआ
जी,
है।
मालूम।
तो 155 की आपने नोटिस इसलिए नहीं दी क्योंकि आप मैजिस्ट्रेट के पास नहीं गए।
नहीं गए पायलट और अभी
ठीक है।
इन्वेस्टिगेशन की स्टेज भी नहीं आई।
नहीं तो फिर कह रहे आप मुझे ऐसी चाय पिलाने के लिए मत बुलाओ।
पायलट 160 के तहत तो किसी को भी बुलाया जा सकता है, वो आके इनोसेंसी प्लीड करे।
फिर आप डिस्क्लोज करें ना, ये ऑफेंस है, ये एफआईआर नंबर है, आपको इसमें बुलाया जा रहा है। वो देखिए दो मुख्तलिफ तरीके कार है। एक सीरियस ऑफेंसेस जिसको कॉग्निजेबल कहते हैं, एक नॉन सीरियस ऑफेंसेस नॉन कॉग्निजेबल। ठीक है, कॉग्निजेबल में आप जो मर्जी करें, इनको अरेस्ट करें, एफआईआर करें, या अगर अरेस्ट नहीं करना चाहें 160 का नोटिस दे दें। ठीक है, नॉन कॉग्निजेबल में आपको मजिस्ट्रेट से पहली दफा दस्तक देना होगी, फिर नोटिस देंगे, फिर दूसरी दफा दस्तक देना होगी अगर इनको आपको अरेस्ट करना है। तो दो अलग अलग चीजें हैं। या क्योंकि ये जब आपने कंसीड कर दिया कि ये आपने एफआईआर नहीं रजिस्टर की है, फिर आप ऑटोमेटिकली 160 का नोटिस दे ही नहीं सकते। फिर आपको 155 का नोटिस देंगे, वो भी मैजिस्ट्रेट के बाद। जहां तक हमें बात समझ आई है, अगर आप हमारी समझ गलत है, हमें
एफआईए का तरीकाकार डिफरेंट है।
जी,
एफआईए का तरीकाकार डिफरेंट है।
एफआईआर का
जो रूल्स हैं,
सॉरी प्लीज नेवर से दिस, कानून में तरीकेदार। आप ये ना कि एफआईआर का तरीकेकार डिफरेंस है, ये कोई चीज नहीं होती है कहने की। आप कानून में बता दें, या एफआईआर के कानून में कोई ऐसी गुंजाइश है, बता दें हाँ जी ये शिक है, इसके तहत हम कर सकते हैं।
इंक्वायरी जब
नहीं आप बताएं, ऐसे नहीं करें, हवा में नहीं करें। आप मुझे प्रिसाइज प्रोविजन बताइए।
हाँ है, देता हूँ एक सेकंड आपको।
क्योंकि आज हमारे सामने सिविल वकील फंस गए ना क्रिमिनल मैटर में। ये आप देख लीजिए ये पॉइंट, अगर आपके पास फौरन जवाब नहीं है।
तो ये एक्ट और रूल्स इसके बाद
फैसला है 1989 के इंक्वायरी विदाउट रिकॉर्डिंग एफआईआर।
ये पता नहीं क्या लिखा है। नहीं वो कभी कभी तो वैसे बहुत से आ जाते हैं।
वेरिफिकेशन ऑफ कंप्लेंट माय लॉर्ड, सेक्शन 4 है इनका।
किसका, कौन सा कानून पढ़ रहे हैं?
एफआईए इन्वेस्टिगेशन एजेंसी इंक्वायरीज एंड इन्वेस्टिगेशन रूल्स 2002।
हाँ,
मैं रूल 3 से माय लॉर्ड स्टार्ट करता हूँ। इनिशिएशन ऑफ एक्शन बाय एजेंसी, रूल 3 माय लॉर्ड, सब सेक्शन 1।
जी
The agency may, subject to Rule 4 and 5, initiate an inquiry.
दोबारा बताएं कौन सा सेक्शन है?
Rule 3, my lord.
हाँ,
The agency may, subject to
ये
rule.
तो नहीं है, कोई पता नहीं कहाँ से पढ़ रहे हो आप। FIA is designated as an investigation agency.
Already, inquiry and investigation rules 2002 है. Rules 2002. 2002.
अच्छा, ये FIA के रूल्स पर।
जी, my lord.
अच्छा।